Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Good afternoon and welcome to the Southwest Florida Real Estate Update. I'm Michael York with the York Real Estate Group, and I'm joined today by our host Jim York and his guest Don Ross of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, Don, thanks for coming on the show this month.
Thank you for having me.
I guess the topic we're going to be talking about is filling out contracts properly in the process of working with buyers and sellers. So, I guess our first step might be is when we're out talking with buyers, showing them property, is we show them different communities, different areas.
Right,
We try and pre-qualify them, first to make sure that they can afford the home that they're looking for. So we introduce them to some banks and get a little pre-approval letter and kind of go from there. And then once we have that, then we can kind of go out and start looking at properties of what type they would be interested in. If it's a community or they're golfers or whatever it might be in the Naples area. So then after we finish that process, we obviously go to a contract. And maybe maybe you want to start to explain how you work with some of your clients with.
Well, I'd love to. What I run into, and I thought this was interesting, you sell real estate for a living, I do the closings for a living. I get a lot of situations where individuals come to me who have reached an agreement amongst themselves. They might be neighbors in a condominium.
Right.
Could be family members. We call them FSBOs, for sale by owners. And I usually, get a phone call and can you help us and do you do this and how much do you charge? And my answer has always been zero. And I tell them, if I can get everybody in the room, I get them all in my office, we get them around the conference table, I will go through the contract with all four people if it's two couples.
The buyer and the seller.
Buyer and the seller, explain our contract,
Right.
The seller's disclosure, hit the high points so that they have a clear understanding of what their rights and responsibilities are, what the inspection process is, what's the point of a deposit, and various other issues. It's one of those things where you really want them in the room. I can tell when I'm looking at someone whether they understand what I'm talking about.
Right.
You get some people who are just shy or they get embarrassed to admit that they don't know this or that. And I always tell them, I say, I do this for a living. I've done thousands and thousands and thousands of these. So don't feel bad, that you don't understand anything about this. It might be their second home they've ever purchased in their entire life. Because I can't do what you do for a living.
Right.
This is what I do. My job is to translate this into English for you. So I've, over the last 30 years, developed a method. I have them all around the table.
Right.
I tell them it's free.
The wine isn't, right?
The wine isn't, no,
Okay.
but it's cheaper and easier in the long run if you give them the free time and explain it, and then the whole closing tends to go so much smoother. They don't ask for things they aren't entitled to. They end up being friendlier. They're across the table from each other, and they understand. Depending on where they come from, they understand. The differences between living in Naples, Florida versus Chicago or Canada or Europe. And each one is different with me, and I'm sure each lawyer does it differently. But if you want, I can just go through a sample, which varies.
I think that's what we should do is, how do you start? I mean, I basically want to tell them when we do the contract, I tell them this also when we're showing the properties, what is included in the house that we're purchasing, because that can always be a problem. We just updated the contracts that make it a little bit more clear than it has been in the past.
Well, I always try to use myself, but our NABOR contract, that's the one I'm looking at, it was just revised in March. We have 13 lines of tangible personal property, so I'll go through it with both sides to make sure those things are meant to be conveyed. The entertainment system, any security devices, things of that sort. And then there's lines 8 where you can add additional items. If there's furniture and so forth, you can make reference to it there. And line 14, they have things that are excluded. And I'll give an example. I'll say, at one point I had a crystal chandelier in my home. That was my grandmother's. So if I were selling my home with that chandelier, I would exclude it from the contract. So I try to give examples to people because they, again, might be too shy or too embarrassed to say, I don't understand what you mean by a fixture. I give them
Right, and
examples.
from our standpoint, hopefully the listing agent has communicated that to the other realtor that might be representing the buyer, that chandelier is not included in the purchase of the home. It should be documented somewhere.
Yeah, I'll get right nuts and bolts just so they understand, give them hypothetical examples for each one.
Right.
It's like painting a picture for them.
It is. That's the best way to do it.
And then we'll get into who the seller is. And that's a big deal. I have one I'm doing right now that I had to refer to a probate attorney before we could even figure out who the seller was. The title was in the name of a husband and wife, but they were as tenants in common, and they were from another state. And I referred him to the probate lawyer, and ultimately what ended up happening is the surviving wife owns 5/6 of the property, and the 3 kids own 1/6. So at least now I know who my sellers are, and I get all the appropriate parties signing it, because you don't want a situation where you put all this work in, the buyer's done all these inspections, they've gone to lenders and spent money, and then you find out, oh, you need this one other child or adult to sign, and they refuse
to sign.
and now it's my fault or your fault. So determining who the seller is, if it's in a trust, I want to see the deed. A lot of trusts are done out of state, and they might run afoul of our homestead laws in this state. I've had this pop up in title insurance commitments quite frequently, where they're doing things that Article 10, Section 4 of the Constitution prohibits. So the underwriter will require somebody else to sign the deed in addition to who's on the contract. So the way we look at the trust, if it's in the name of a corporation, does that person have authority to sign the contract? If it's a limited liability company, where in the operating agreement does it say you can sign this contract? How many members are there? Should we get all the members? So determining the seller is really critical. The buyer, I always tell, this contract's assignable. So if you're from Canada or France or wherever, we can look at that later, how you want to take title. Because if you have to wait for Canadian counsel to look at it, it could delay it and you might lose the transaction. So that's my beginning part. The proper seller, the buyer that's flexible.
What's included?
What's included? What's excluded?
That's right.
You give them an example, and then I get down to the price.
What is that?
Well, they usually have a dollar amount. Sometimes they don't, but they don't know the function of the deposit.
Right, that's true.
And I'll always, it's always like a new thing. So you have them around the table. You want to have a completed document. So I'll say, this contract requires a deposit. You got to have something. Otherwise, you don't have mutuality of remedies in the contract. Why? Well, because there's a default clause that says the only remedy the seller has against the buyer, if the buyer decides they don't want to buy it, is to take the deposit. That's it.
That's it.
So if you put down 0 as a deposit, just because we're neighbors in this condo and we're really great friends, and then somebody changes their mind, you really don't have a contract. It's nothing that can be enforced. And then they'll ask me, well, what's normal? Customary is somewhere around 10%. As the price goes up, that might drop. The point is you don't want too small a deposit.
Right. Not too big.
And even too big is a problem. It could be set aside by the courts. So you want enough so that the seller feels comfortable and the buyer will pause before they walk away from the transaction.
That's
So
right. That's how I explain it to them.
and lots of times they'll do 5%.
Right.
Because they're friends.
That's
They've
right.
met around the pool and things like that. So
Maybe explain to them that you can put the deposit on now, or you can put the deposit on 3 days later, or so many days later.
You can do
after
it
the
later.
effective date.
Usually they're sitting there with their checkbook.
Right.
I'm not,
Right.
you know.
Well, I know, but I'm just saying from my standpoint, that's
Sure.
what we're, from a realtor standpoint.
Sure. Then we look at closing dates.
Closing dates.
Now, the big problem with closing dates is everybody and their brother picks the first day, the 15th day, the 31st day.
Mm-hmm.
This is, what is today? Today's the
25th.
25th. The last day of this month and the first day of the next month, I'm absolutely slammed.
Mhm.
I mean, it's a disproportionate amount of closings fall on those days. And that not only impacts me, but it impacts the movers, it impacts the lenders, because they get all their work on those days. So I recommend, one, let's look at the calendar, make sure it's on a weekday, because
Right.
whenever I don't look, it's Saturday or Sunday, and I feel silly. And then let's try to avoid the 1st, the 15th, and the 31st. And if you're getting a mortgage, we need to leave enough time for the lender to process, to underwrite the loan. And a lot of these people have done this before, but very few of them have done it since DoddFrank. And they're not aware of how much more investigation is involved and how much longer it takes.
Right.
And then I get to give them my little speech about use an in-state local lender, which you and I have talked about a million
That's
times.
Right.
It's just so much easier with the in-state lender. And with the mortgage situation, we'll talk about furniture. If there's furniture involved, you can't have it on the contract.
That's true.
They don't want it there. And I have a separate agreement of that. And then, if there is financing, we go through the financing contingency. I don't know if you want to go through that now, or?
Well, let's take a little short break,
All right,
and then
then we'll go through
we'll
it.
come back to that and just explain it shortly.
Okay.
We'll be right back in 1 minute here.
Thinking of buying or selling a home in Naples, Bonita Springs, or Estero? Think of the most experienced realtors. The York Real Estate Group of Downing Fry Realty. Let's have a look at what the McLeans have to say about their experience working with the York Real Estate Group.
Jim York was our broker in acquiring our present home in Bonita Springs. His knowledge and integrity made the process go very smoothly.
It was a pleasure doing business with Jim York. Everything was done in a superbly professional manner.
Welcome back. Don, let's talk a little bit about finance contingency, because I guess, a lot of people don't really understand that.
Yeah, again, when I have the people in the room,
Right.
I'm very aware that this is relatively foreign to them. I'm very aware that I can't give them too much information or they won't absorb it all.
That's true.
So I'm constantly trying to decide what is the most critical factors, what can they come back to me with later on. I give them my cell number, it's on my card. So they have an overall understanding of how the contract works. But if there's financing involved, I'll discuss paragraph 4 of the NABOR contract. And I tell them they have 5 days to apply for the loan, and they have 45 days with this default language to notify the buyer whether they have loan approval or not. And then I explain after that they get additional rights. They can terminate the contract, the seller, they can if they get another offer for more money. And they always say, no, we're friends, we're not going to do that. Or the buyer can if the bank actually turns them down, and for reasons in paragraph 4. So the financing, I focus on the furniture. This is here. The point of it is to protect your deposit. If they're family and they're only putting a few dollars down, just enough to make the lender happy, because the lender generally wants to see a contract. Even if you're buying it from your mother, they want to see a contract.
Right.
I'll explain that the point of this is to protect your deposit. You have to apply for a loan as set forth in this contingency, with this interest rate,
Right.
this dollar amount. Otherwise, your deposit might be at risk. You can't have your contract say it's subject to you getting an 80% loan, and then you go in and apply for a 90% loan.
That's right.
And expect your deposit to be entirely safe.
Right.
This clause was modified in March to flesh out what due diligence is. The buyer has to actually try to get the loan. They have to fill out all the applications. They have to give all the information and pay all the fees the lender asks for. If they ask for tax returns, you give it. If they want to see canceled checks, you give it. If they want an explanation on how that money got in your account, which happens
All the time.
all the time now, you have to give it. So, you know, that only kicks in when we have our financing, which is probably a third of the time.
And typically, they have so many days to do this, right? The
They do.
contingency.
With DoddFrank, I try to warn them that you never know how much money somebody has when they're sitting in your office. But I warn them that there have been consequences from DoddFrank, and one of those consequences is that it takes longer. They have to actually see that you are able to afford this mortgage, and what they consider income under the new law might not have been considered income or under the old law. You could have $10 million in a 401k, and they may have a problem unless you have periodic distributions from the 401k. So I'm alerting the wealthy clients
Right.
that it's not enough to have money. They want to see what they consider income coming to them on a regular basis.
Okay, and then the next part you want to talk about is maybe if they're in a CDD or not, or
Well,
what do you have on your list next?
I have the inspection
Inspection,
process. The inspections are one of those things that you've got to, you're dealing with people from different states. You get the northern states, they're not used to mold necessarily. It's not as prevalent in real estate closings up in Massachusetts or Georgia or New York, where I have family who do this kind of work. So I basically what I tell them is you have 15 days to do your inspections.
That's true.
You have 5 days to ask the seller to fix it or remediate it. You got to give them a copy of the full report. If you're asking for a credit, you got to give them a copy of the estimate.
Right.
The seller then has 10 days to say yes or no. And the seller can actually say no. And if the seller says no, there's something that is not defective under the terms of this contract,
Right.
the buyer has 5 days to cancel. I have one right now where the buyer is insisting that the driveway, which is all tile, is not level enough. And they're trying to characterize that as a defective item. You know, it's not.
Right.
You got to look at the language on page 6, I think it is, and it gets into what's defective and what's not. You know, toxic or pathogenic mold
Right.
is a biggie. People up north don't seem to deal with this as frequently as we do. So my way of explaining it is, again, using my home, my own personal experiences, actual closings I've run into, and I tell them it's defective if it's toxic or pathogenic, and it's not very exact because it's subject to atmospheric changes outside. It's raining now, so you know that will make the air be cleaner outside than it would normally might be. So you got to look at the report like you're a detective and try to figure out why is that count inside high. Is it because the air handler needs to be clean? Are the ductworks dirty? Is there a hole in the grout in the shower? Is there a small leak somewhere? So the mold report can actually be your friend. You know, it can point out little things like you need to service your air handler, or the overflow drain has too much algae growing in it. Well, we even had one, I don't know if it was with you or not, somebody had left a pail of water inside the closet where the air handler was, and that made the mold spike.
No, it wasn't me, thank God.
This is, you know, so it's, you got to be the detective. Where was the device when they were measuring the levels? What kind of mold is it? And again, with my northern friends, I'll say, well, we're next to the Everglades, and you know, and Aspergillus penicillin is a very common mold. It's from plant decaying matter. So don't lose your mind when you get the report. The terms are in Latin. Look for what causes this. Is it just dirty, or is there a small leak? And it's nice to get the small leak or the caulking that started to shrink because it's facing east. little things like that. So that's basically how I do the inspection process. The one caveat is we have a line 295, again, and I've said it so many times, I know I'm repeating myself. The cost to fix something cannot be more than its fair market value. And again, I have the people around the table, so I want them to understand that if the inspector says the air conditioner isn't working at optimum levels,
Right.
If it's 12 years old, it's not worth much.
Right.
And that's the most the seller is responsible for. I mean, you and I know this by heart,
know, but it needs to be explained.
You got to give them the basic stuff,
Right.
and so that their expectations are reasonable.
That's right.
And keeps the emotions level, and it just seems to go much smoother.
Don, let's take another little short break here
Sure.
before we go into, I think the CDD is next.
Sure.
But if not, we'll hit whatever you want. We'll be right back in 1 minute.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Well, Don, let's pick up from our last part here and continue on CDDs. Do you explain that to them, what a CDD is?
The way I explain it, and again, I know other lawyers probably explain it differently. I really haven't watched other lawyers explain it. I just do it
Right.
the way I do it. It's a community development district. So if you get a developer who bought a large parcel of land and they're going to put in streets and utilities and so forth, they need to raise the money to do that, and they do that selling bonds. And the bonds get repaid by affixing it to the real estate or the ad valorem tax bill, and it gets paid off over time. And under this contract, if the buyer is going to assume an outstanding CDD, because it's part of the tax bill,
That's right.
you have to attach a form to the contract that shows the approximate outstanding balance. So
Right.
they don't get sticker shock when they find out it's $29,000. I have one now where the outstanding balance is $29,000. It's all up front, nobody's being surprised, they see it's part of the tax bill. It gives them one less thing to complain about when they get to the closing table, or even worse, after the closing when they
Right.
find out about it.
That's right.
So you want to tell them beforehand that, hey, there's this debt that encumbers the property,
Right.
and you're agreeing to assume it. Otherwise, your life and my life will be a nightmare after the closing.
No, there's a form that has to be filled out.
It's definitely,
properly,
and we get a
and
payoff.
signed.
We get a payoff. They have an MSTU, multiple service taxing unit, which is more to do with annual maintenance, like in Pelican Bay, cutting the grass in the meridians, taking care of the plants and so forth. There's no payoff for that. It's just an annual fee. So that's both in the same paragraph, the CDD, the Community Development District, and then the MSTU, the multiple service taxing unit. But other than that, people want to know their costs.
Right.
Everybody wants to know, what's this going to cost me? So we have standards E and F. And standard E is seller's costs and expenses, and F is the buyer's. So the main thing for the seller is the documentary stamp taxes on the deed. It's $7 per thousand. So if it's a $100,000 property, it's $700. That's what it is.
That's what it is.
The buyer's main expense, unless it's in Lee County or Charlotte, is the title insurance. And that's $5.75 per thousand. Then it graduates to a lower level as the price goes up. And so I explained, there was a policy dictated when they implemented this contract that the seller and the buyer will try to share the expenses. They're not going to hit the one person with both.
Right.
Okay? And then there's, the seller might have some modest fee for the preparation of the deed, the bill of sale. There's an affidavit that's required for title insurance. Getting estoppel letters from the county or the city or the association, as the case might be. So I go over everybody's costs so they don't have any sticker shock. the next thing, I mean, if it's a condo, I almost always offer to read the documents and go over it with the buyer. They're rather intimidating, the documents. They're thick. A lot of them are right out of the statute. Some of it is modified use restrictions, things like that. So I read quite a few of these things and offer to the buyer. I will read them. I'll call you on the telephone. We'll go over it together. If you have any special concerns, please let me know. If you have adult children that you want to let use it, or friends that you want to let use it when you're not here, let me know. So we look specifically for those things in the condo docs. And we'll look at the year-end financial statement to look at reserves. Is there enough money there? Is it a healthy financial association? Or they have zero reserves, and you have old roofs, and you're facing a special assessment.
Right.
So the way I explain it is I try to point out things that affect your day-to-day use of the property and money.
Mm-hmm.
That's what people tend to care about.
That's right.
And then I ask them, is there anything special? And then I cover myself by saying, of course, I recommend you read the whole thing.
Right.
Because you never know
That's right.
what might be important to them.
That's right.
I mean, everybody's different, so you don't know. And a lot of, the law is different for condominiums and homeowners associations. What's required to be given with condos is a whole bunch of documents, but no summary of the maintenance, special assessments, resale fees, transfer fees, capital contributions. That's not in any statutory required form.
Mm-hmm.
HOAs, on the other hand, homeowners associations, mandatory homeowners associations, are required by law to give a one-page summary.
Right.
The special assessments, what the maintenance is, whether there's any rent or land lease involved, and then at the bottom of the form it talks about how all the restrictive covenants are in the public records or might be available through the management company, and you should look at them before you sign this form, which nobody does.
Right.
So I offer to read all that stuff, just again so that
Mm-hmm.
they don't get upset that their dog's not allowed or their adult child can't come down by himself, because once in a while you get that. Or they might limit how many times a year your family can come down. And I make a joke out of it to lighten the mood a little bit, saying that I'm one of 6, my wife is one of 8, and we might not want all those people calling and asking, can we use your condo? It causes family issues. So, that's what I do with the condos. Time-wise, you want me to?
Yeah, keep going.
Okay. And all these are different. Through the entire process, I'm looking at the people. Do they seem to be absorbing it? I'm not talking as quickly as I am now, because they're usually asking me questions. So, I go on segues with them depending upon what questions they have. If they're from another country, they almost always get concerned about how they're going to hold title to avoid U.S. estate taxes or to avoid income taxes. They're worried about withholding when they sell the property. So I have a degree in taxation. We'll talk about that. And then, we have at the end of the contract, we have some exculpatory language representations where the buyer holds the broker harmless from any failure by the seller to disclose material facts. And that's our seller's disclosure form right here. And also, the parties agree that the broker will not be liable for any referral, recommendation, or retention of any vendor. Now, some brokers will give you 3 names because that's what their broker tells them to do. Others, they have a team, and I'm a big team person. They know they do a good job. They know they're licensed. They know what you expect. You haven't had any negative feedback, and they'll recommend their particular inspector or repair person or lawyer or title company or whoever.
Well, Don, we're running out of time here, but I think you've done an excellent job explaining this, and I hope our viewers think so too, and hopefully we'll see you next month, okay?
Right.
Thank you very much.